federal sentencing, because approximately 96% of all people charged in federal court end up before a judge to be sentenced, the most important part in most of the cases is sentencing. What is the sentence going to be? The first thing that happens is there is a report written by the probation department, a sentence memorandum written by the defense, and a sentence memorandum written by the U.S. Attorney's Office. There are certain things that have been agreed to, for example, a guideline range. Southern and Eastern District, everyone's in agreement as to what the guideline should be, and you have the right to argue outside. In New Jersey, if you agree to what the guidelines are, you can only argue within the guidelines. You can't argue outside. Once the court establishes, and they have the final say as to what the guidelines should be, then you're in a situation in which you have to make arguments as to what the sentence should ultimately be. Now, there's two ways to go about this. One way is the way where the defense lawyer just argues that it should be low, or he wants the least amount of punishment, and they're not very specific. I think that is a poor way to argue. I think that for my clients, I want to argue for the lowest possible sentence that they can get and that the court will buy into. You want to come in there knowing what kind of sentence that you and your client want, and you want to go for it. Next step, you have to have some law as to why your sentence, if you want to argue outside of the guidelines, why it should be outside of the guidelines. Now, the nice thing about just practicing in general in the Eastern Seaboard is that there's so much law written about it. There's so many laws that have been decided by the Second Circuit Court of Appeals or the Third Circuit Court of Appeals that with some proper research, you can find decisions determined by the Court of Appeals that says that if the trial judge finds a certain fact, he should go outside of the guideline. And I make it my point that if my client pleads guilty, we go in there for sentencing, that I have the most on-point legal memorandum for my client. And then when we go into the court for that hearing on what the sentence is going to be, I let that memorandum sing. I do everything I can with both the law and the facts to get my client the best sentence possible. And I think that's the way it should be done, and that's the way I do it.